I was just in a protective order trial last week. I can't go into too many details because protective orders are very, very confidential. You actually can't even look them up unless you're the attorney of record. So a lot of times it's family members who have some sort of dispute, ex-husband, ex-wife situation like that where there's a dispute. But the situation is it's a protective order, meaning one party felt like they needed to be protected from another party for whatever reason. So a protective order is a civil matter. It's between the two parties, the petitioner who files the protective order saying they need to be protected, and the respondent, which is the person who is responding to the petition saying a protective order isn't necessary here. It's not in front of a full jury. It's just in front of a judge. So both sides make their argument to the judge, and the judge decides whether or not a protective order should be put in place. And a protective order is what it sounds like. It's an order of protection that bans one party from having contact with another party. Again, that's usually people who had some sort of relationship in the past, and now, for whatever reason, they want that contact to end. So it is similar to a regular trial. The party bringing the protective order, the petitioner, goes first. They lay out all the reasons they think they need a protective order in place. That includes presenting evidence, and they still have to follow, their rules of evidence are still involved here. So hearsay is not going to come in. They can call witnesses. They can do everything, sort of similar to a regular trial, what it would look like. And then when they're done, the respondent does the same kind of thing. They present their case, and maybe the judge will have questions at the end that they can ask either party, but it's supposed to follow the rules of a regular trial. Now, because of the nature of them, and because oftentimes people are unrepresented in these trials, it oftentimes breaks down and ends up in two parties just yelling over each other to the judge. The judge is trying to maintain order, and it kind of descends into chaos, and we see that a lot. So it is very important to fight having a protective order against you. Number one, it sets you up for some sort of future charge. If this is a person that maybe if you're ex-husband and ex-wife and you have a kid together, something like that, or there's some relationship with a kid, you're going to need to have contact with that person in order to set up childcare. It sets up a situation where you could be looking at a violation of the protective order, and if that happens, for any number of reasons, it doesn't just have to be if there's a kid involved, it could be for any reason. A criminal charge can be filed, an invasion of privacy charge can be filed, and that can be charged as a misdemeanor, or if it happens more than once, it can be charged as a level 6 felony. It can stick with you. It can restrict your ability to have a firearm. There are all sorts of collateral consequences that can come from a protective order being granted against you. So there are definitely dangers in appearing at a protective order hearing without an attorney. While we were sitting there waiting for our case to get called up, there were several people who commented, "Oh, I didn't think it would be like this. I thought I would just kind of explain my side and this would be fine." And before our case got called up, every person before us, that protective order was granted against the respondent. And there was sort of a sense of shock when it was granted because everybody has their side of the story and they think they're in the clear. But without an attorney there, it's difficult to get your story across. So a lot of times both parties are kind of yelling and the judge sees the respondent in that light. If the petitioner is saying he can be violent, he can be angry, something like that, and the respondent is over here yelling, trying to defend themselves, well, the judge sees that in them. And it's easier for the judge to grant that protective order if they see you acting that way. Now, another thing that people don't often think about is sometimes the basis of a protective order could be something that could also be filed criminally. If they're saying someone was violent towards them or some type of sexual act occurred that shouldn't have occurred, if you are under oath responding to that, you open yourself up to criminal prosecution on that. And these are recorded, you're under oath. So the state can use that as a sworn statement against you. So it is so important you have an attorney in there protecting you. First, to make sure you put your story out there in a rational way that the judge can understand, but also to make sure you aren't opening yourself up for criminal prosecution. Our client was very satisfied. Like I said, every person who came up before us, that protective order was granted. We used the rules of evidence to our benefit. We made sure that the petitioner's case was limited only to what should be allowed in. And so the case was thrown out. We didn't even have to present a case. We didn't even have to put our client up there under oath to testify and tell his side of the story because we were able to limit so much of what was presented that the judge had no choice but to dismiss the claim before we even presented the case. And that's called an involuntary dismissal. It's something similar to what you would see in a bench trial in a criminal case, where if the petitioner doesn't meet their burden, then the case ends right there because there's nothing that they haven't stated enough for us to even have to defend against. So the case was dismissed outright. Our client was very happy. He even commented, "I'm so happy I hired an attorney after seeing everybody else have their protective order granted." So it is so important to have an attorney with you. So protective order cases are much faster than criminal cases. Oftentimes in a protective order, if the judge, sort of similar to a criminal case, if the judge finds sort of a probable cause exists, or that the petitioner meets a certain burden with their initial filing, they can grant what's called an ex parte protective order, which means it's granted without a hearing. Now, there still has to be a hearing, but while that protective order is pending, it's granted until that hearing. Now, basically, it's going to have to come within 30 days. So it all happens very quickly. So as soon as you get that notice of a protective order filed against you, it's important to let us know so we can get that petition. Like I said, it's confidential. So we have to get it right away and start figuring out how to defend against these claims that are made against you. Yes, it can be too late sometimes to hire an attorney. If that protective order, if you got notice, and if that protective order is granted, we can't really go back and fix it. So it's important to get us on board ahead of time so that we can be there with you. Now, if you didn't get notice, sometimes this happens. If you didn't get notice because you were living with the person who filed the petition for the protective order, you moved out because of for whatever reason, that happens a lot, and the notice was sent to your old place of residence. If you don't get that notice, we can probably file something to reopen that protective order. But if you get notice and you don't appear with an attorney on time, it's very likely that protective order is going to be granted, and our response is very limited what we can do at that point. So if you've got notice of a protective order hearing, whether the claims are absolutely valid and you think they should be granted too, or whether they're based on nothing and it's complete nonsense, call an attorney to talk about your options right away, because we're going to be able to pull that protective order. We're going to be able to see the allegations against you, and we're going to be able to help build a defense and see if it's something. Do we want to fight it, or is it something where we don't want to risk you being put under oath and having to testify to these things and open yourself up to criminal prosecution? That's all a strategy decision we can make together based on what you know about the case, what the person is filing against you says about the case. We can come to a decision on how best to handle it for you. And remember, always plead the fifth. Give us a call, 317-632-3642.